afternoon. We thank you so much for being here today for our presentation on having reservations, navigating an insurer's reservation of rights in litigation. First, for introductions, my name is Jill Meixel. I'm a partner at Krokidas and Bluestein. I head the firm's employment practice area and co-head its litigation practice. I'm here with my colleague Bettina Toner, and she's going to introduce herself in a moment. But first, I just wanted to tell you all a little bit about K&B. So K&B is a mission-driven law firm. A large part of our practice involves the representation of nonprofit organizations, charter schools, and other public entities in a variety of areas, including employment, education, litigation, health and human services, real estate, and transactional work. I'm now going to turn it over to Bettina to introduce herself.
Thanks, Jill, and hello again, everyone. As Jill noted, my name is Bettina Toner. I'm also a partner at Krokidas and Bluestein, and I practice in the education and employment practice groups at the firm. The reservation of rights issue comes up frequently in my practice and in Jill's practice. Oftentimes in the employment litigation realm, in which we both practice, but, in other areas, litigation areas that we deal with at the firm. So, while we deal with these issues often, they come up all the time. We talk about them frequently. We advise clients on them frequently. We've found that it can be confusing to clients sometimes and oftentimes, particularly at the outset of litigation. So we're hopeful that by providing this overview today, we're not going to do a deep dive into the weeds of, insurance law, but we thought it would be helpful to kind of give a high-level overview about the reservation of rights issue because it does come up fairly often. So we thank you for joining us today, and I'm going to actually not going to hand it back to Jill. I'm going to just jump right in.
I think I'm going to do the agenda.
Oh, let's do the agenda.
Thanks. So just going to go through the agenda quickly with all of you so that you can see what we're going to cover today. So we're going to start out by setting the stage here, and Bettina's going to give you an overview of some basic principles of insurance law, which will be really helpful in order to fully understand what a reservation of rights means and when it comes into play. So in talking about these basic principles, we're going to talk a little bit about what a duty to defend means and what a duty to indemnify means. And then we're going to jump right into a discussion about reservations of rights and what that means. Then our discussion is going to turn to the second big bullet point, which is conflicts of interest and reservations of rights. And in this section, we're going to discuss how a reservation of rights by an insurance carrier impacts an insured's rights and an insurer's obligations. And then in terms of that, we're going to talk about how a reservation of rights provides an insured with the right to select independent counsel, and how a reservation of rights obliges an insurer to pay the reasonable attorney's fees of their chosen counsel. Then we're going to talk about oftentimes an insurance company will issue guidelines for its defense counsel to follow in a matter. And we're going to talk a little bit about how a situation where compliance with those guidelines could adversely impact an insured's rights and where you can push back. Then we're going to talk about when all else fails. If you're not able to get through to a carrier and you think your rights aren't being followed or permitted, we're going to talk about bringing a claim or a demand letter under Massachusetts law, which is Chapter 93A and Chapter 176D. And then we're going to just give you a few additional tips to wrap up. Two notes, if anybody has questions, you're welcome to submit them in the Q&A box. To the extent we have time at the end, we will answer them. And with respect to the slide deck, we plan to circulate it after the presentation to all of you. So you will be getting a copy of this. And with that, I'm going to turn it back over to Bettina to talk about the basic framework of insurance law.
Great, thanks, Jill. So let's orient ourselves with a brief review of some basic principles of insurance law. So first, an insurer has a duty to defend when a claim is or may be covered under an insurance policy. Now, that duty to defend is broader than a duty to indemnify the insured, meaning that it's not sufficient to just pay a judgment for damages on behalf of an insured. In fact, the insurer's duty kicks in well before a judgment or settlement in a particular matter. Next slide, please. So when does an insurer's obligation with respect to with respect to a litigation matter kick in? As you can see here from this quote from Massachusetts Appeals Court case, an insurer's duty to defend is triggered when the allegations in a third party's complaint against an insured are reasonably susceptible of an interpretation that states or roughly sketches a claim covered by the policy terms. In other words, a duty to defend arises when there's a possibility, not a probability, of recovery under an insurance policy. So the underlying complaint need only show, through general allegations, a possibility that the liability claim falls within the insurance coverage. There's no requirement that the facts alleged in the complaint specifically and unequivocally make out a claim within the coverage. Next slide, please. So continuing with our discussion or our review of some basic principles of insurance law, let's talk briefly about a reservation of rights. And we'll go into more detail on some of these points. But what I do want to just sort of remind folks about is, what are we talking about when we're talking about a reservation of rights? So an insurer may agree to defend the insured, but issue a reservation of rights if coverage, defense, and indemnity is not unequivocal. In other words, if the insurer could decide not to cover the claims at any time. In other words, some examples of where this might play out would be a reservation of rights could come into play where an insurer has a duty to defend a matter, but not to indemnify. In other words, where it might cover some claims, but not others. Another example would be a claim that may not ultimately be covered depending on how the facts play out in litigation. Or there may be a reservation of rights in a situation where the plaintiff is seeking both monetary and non-monetary relief. So monetary relief, but also injunctive relief, which is not monetary. Next slide, please.
So now I'm going to talk you through a scenario of how to navigate an insurer's reservation of rights. And I will say that, we get calls often from clients after, if they receive a demand letter or they receive, get sued, it's alarming. So they'll call us and they'll say, what do we do? And my advice always is, in the first instance, do you have insurance? Particularly if it's a large claim, because obviously you buy insurance in order to be able to use it in a circumstance like one where somebody sues you. So I'm going to just take you through the steps that we follow when a client gets sued. So first of all, take stock. Step one, take stock of all of your insurance policies to assess whether or not you may have insurance to cover a claim. Some claims are covered, some claims might not be covered, and you need to assess what the situation is so that you can proceed accordingly. And I will say, if you do have insurance policies, you should most certainly read those policies, which can be extraordinarily dense. But don't make the decision alone as to whether or not that you think the claim is covered. So in other words, don't read the policy and say, oh, you know what, I don't think the claim is covered, so I'm just going to move forward and, hire a lawyer and pay for my defense. Instead, either if you have an insurance broker, you should reach out to the broker to try to help you determine whether it's covered and to report a claim to the carrier. If you don't have a broker, you can go directly to the carrier to report the claim. So step two, which I just addressed, is you report the claim to the carrier, to the insurer, either through the broker or directly. And I will say that so claims have deductibles or retention amounts. So in other words, most policies require insured to pay a certain amount before the insurer will take over the costs of the claim if they're covered. I have seen retention amounts in varying amounts, from anywhere from $5,000 all the way up to $150,000. It really depends on on the matter. It depends on what your policy says. It depends on how much you're paying for premiums. So this is something to consider, because if your retention is $150,000 and you get sued for $5,000, you should evaluate along with your broker whether or not to report a claim. I will say, and this is very important, that just because somebody makes an initial demand for a number doesn't mean the number isn't going to increase over time. So the initial demand could be something, try to a compromise amount. So don't always use that number as a factor, or as a determining factor in determining whether to report a claim to insurance. As you know, I don't think there's ever really a harm in reporting a claim to insurance. Sometimes I'll get a reaction that, well, if I report the claim, then my premiums are going to go up. But again, this is why you have insurance. You have insurance to help protect you, help pay some of the costs that could be associated with litigating, or in the worst case scenario, a judgment that could be large. So, going on to step three. So now you've reported the claim to your carrier either through the broker or on your own, and the insurer is going to review the claim and provide a coverage determination. Now, those coverage determinations are typically through a letter, although it really can be done more informally, such as through an email. And the informal coverage determination actually often happens in a circumstance where the carrier is slow to issue an actual coverage determination, which can be a very lengthy, very dense letter. And it usually takes some time for a carrier to reach that conclusion. But in the meantime, you've gotten sued, so you need to do something, and you need to know whether or not your claim is covered for reasons that Bettina and I are going to discuss today. And so sometimes, so it's always important to communicate either yourself or through your broker or through your counsel with the carrier to ask them to make what is your coverage determination, because as we're going to discuss today, what the coverage determination is, particularly if there's no coverage, that's one thing, but if there's coverage but with a reservation or without a reservation, is highly relevant to you and how the case is going to proceed and who's going to control the litigation. So step four, as we indicate here, it's really critical to read the fine print of whether it's an email or a coverage letter to determine what position the carrier is taking with regard to your claim. Typically, the words reservation of rights do appear in either a formal coverage determination, or if it's at the outset of the case and the carrier is just saying, we're reserving until we review further. However, any indication that the carrier could change their mind at some point is effectively a reservation of rights. So a reservation of rights is basically saying at some point the carrier might not cover all or part of this claim. What you want is, in the ideal world, not to have a reservation of rights, in which case they would both defend and they would also have a duty to indemnify or pay any judgment without any restrictions or any limitations at all. Oftentimes, carriers do reserve rights for a variety of reasons, which is why this issue comes up so much and why we thought it would be useful to present today. So, if a reservation of rights is issued either in a formal, long, lengthy coverage letter or in a short email, then it's really critical for you to do a couple of things. Number one, to know your rights as the insured, and that's what we're going to talk about today. Secondly, to understand what the insurer's obligations are. And finally, it's critical that you act promptly to avoid waiving any rights. To the extent you don't act quickly, you either don't, notify the carrier of a claim, or you don't push back when a carrier issues a reservation, but then says certain things that aren't actually, don't give you the benefit of the control you're entitled to, you need to engage with them and communicate. So the next two slides, what I've done here, I thought it would be helpful to sort of provide some actual real life examples of excerpts of what a reservation of rights could be. So these examples I pulled from situations I've had in the past many, many years, and I thought it would be helpful. So just to go through so you know what to keep an eye on at the outset of the case. So the first slide, this is an excerpt from a more lengthy coverage letter. And I'm just going to go through it. So this excerpt says, this letter addresses only those policy provisions that appear pertinent at this time in light of the facts currently known and available to us, without accepting or implying that the allegations have any factual and legal merit. Then it says, we reserve the right to review all coverage issues and not merely those raised by any additional information or evidence. And then in the next sentence, it says, by limiting policy references to those cited, we do not waive any other policy provisions, and we will reevaluate our coverage position if there are any material changes in the allegations or in the facts. So if you ever get a letter or an email that indicates any possible reevaluation, reanalysis, anything about the claims, that is a trigger for you and a red flag for you that this is a reservation of rights, regardless of how it's framed otherwise. I have 4 additional examples here. And again, these are from 4 different coverage letters, a whole bunch of different carriers. So I think most carriers are pretty consistent in how they respond to these things. The first one was a coverage letter that actually had a section entitled Reservation of Rights, which in and of itself tells me that there's a reservation of rights. That coverage letter further stated that all rights under the policy at law and or in equity are reserved fully and mutually. Clear reservation of rights. The second bullet, insurer continues to reserve all rights and defenses available under the policy. Again, clear reservation of rights. The third one, and this is a situation where, a claim is reported and it's going to take the carrier often some time to put together a robust letter. But in the meantime, the insured, you all, want to know what their position is so you can act accordingly. So this one, the third bullet, says, I will be providing a coverage letter in the form of a reservation of rights, which simply spells out the insurance coverages that apply and don't apply to the current facts and the coverages that may not apply to future facts that may crop up. So here, they haven't actually issued the letter yet, but they're basically telling you, we're going to issue a reservation of rights. Sometimes the letters make it seem like there's not going to be a reservation of rights or that the insurance company sort of has it all handled and in control, but the insurance company is not going to tell you what your rights are. And they're not going to tell you what their obligations are. That's why we're here today, so that you all can be aware when these things crop up. And finally, the last bullet point, pursuant to a complete reservation of rights, this matter constitutes a claim under the policy. So again, very clear reference to reservation of rights. As I indicated a moment ago, more often than not, the words reservation of rights are in the letter or the email. But you should be aware that any caveat, any contingency, any reference to there being a reevaluation is basically a flag to this is a reservation of rights. So with that being said, now that you have the general framework, I'm going to turn it over to Bettina to talk about conflicts of interest stemming from reservations of rights, and also to talk about the rights of the insureds and the obligations of the insurer that stem after a reservation of rights is issued.
Thanks, Jill. So why is a reservation of rights important? As we'll see, and as Jill alluded to earlier, it's important because it may indicate a present or future conflict of interest between the insurance company and the insured. So let's talk about how a reservation of rights might create a conflict of interest between the insurance company and the insured. When an insurance company says, when it issues a reservation of rights, it's essentially saying, we're looking out for our interests, the insurance company's interests, as well as yours, right? However, an insurance company owes a duty of care to the insured, including the handling of the insured's defense. So at times during a particular litigation matter, an insurance company and the insured may have interests that may be at odds, right? So in that case, the insurance company may not put its own interests over the insured because that would violate the duty of care. So in light of this potential conflict, the Massachusetts Supreme Judicial Court has held that when an insurer seeks to defend its insured under a reservation of rights, and the insured is unwilling that the insurer do so, either because of a conflict of interest or potential conflict of interest, the insured may require the insurer to either relinquish its reservation of rights, so say it will remove that reservation of rights, or to relinquish its defense of the insured and reimburse the insured for its defense costs. Next slide, please. Ultimately, where a reservation of rights is issued, that gives the insured the right to control the litigation. So if an insurer wants to maintain control over the litigation, again, it must lift that reservation of rights and unequivocally agree to defend and indemnify the insured. An insurer's right to control the insured's defense is limited by defense counsel's ethical obligations to the insured and is tempered where a concurrent conflict exists. And all this means is that, this concept of conflict of interest aligns with the rules of professional conduct that control attorney-client relationships. So an attorney typically cannot represent two clients in the same matter where there is situations where there's a conflict. So when representation of one client will be directly adverse to another client, or where there's a significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client. So in other words, this is what the SJC is getting at when it's saying that if there's a conflict, then either the insurer has to reserve the reservation of rights and just cover the claim without restriction, or it has to allow the insured to obtain their own counsel, and they can protect the insured's interests. Next slide, please. So here's the important takeaway here. When an insurer will not lift the reservation of rights, an insured has the right to maintain control of its defense to avoid that conflict of interest. And that was addressed here again by the Mass Appeals Court in the Moriarty case, where it said where the insurer insisted on proceeding subject to a reservation of rights, the insured was entitled to maintain control of its defense and to seek payment of its legal bills from the insurer. At that point, the insurer was required to reimburse the insured for reasonable attorney's fees incurred by the insured's chosen counsel. So again, this is, a lot. We're going to be talking mostly about Massachusetts law here. Some of this, as Jill mentioned earlier, is not going to be familiar, perhaps, to your out-of-state insurance adjuster or others at the insurance company, because it's very specific to Massachusetts law, but it's important to know these protections for insured. So what else do I want to say about that? So the takeaway here is if an insurer issues a reservation of rights and the insured does not push back and allows the insurer to maintain control, the insured is likely waiving its right to control. This is really important to keep in mind. So for example, in the Herbert A. Sullivan case that we mentioned earlier, the insurer had issued a reservation of rights and the insured did not contest that. And the court said where there's no indication in the record that the insured either insisted on having the reservation of rights removed or in the alternative insisted on assuming control of its own defense, the court there concluded that the insured acquiesced and couldn't at a later point, raise that conflict issue. So it's really important to remember to raise this at the beginning of litigation. So that's conflict of interest generally. Jill's going to talk a little bit more about sort of the reservation of rights quandary that can come up.
So before I get into the quandary, I do just want to highlight something Bettina just said, which is really critical, which is Massachusetts law is unique, and it definitely provides more rights to insureds than other states. And so in my experience, and I think Bettina's experience as well, many adjusters, most adjusters, I don't want to say all, but the majority of adjusters are not located in Massachusetts and do not know Massachusetts law. And in other states, when they're when they're handling claims, they're not faced with these issues because it's not the law. So it's really critical. I find that we very frequently have to educate adjusters as to what Massachusetts law is because they just don't know. And it's always really critical to have really good, solid, communicative relationships with adjusters. But sometimes you just have to educate because, again, they don't know this. Many of them, not all of them, many are not lawyers. And B, they just don't know the laws of all the states. And C, a lot of folks, even in Massachusetts, don't know about how this works because it's a little complex, which is why we're here today. And so they don't bring it up and they just cede to whatever the insurance company is telling them because they just assume, which is fair, that the insurance company has it all covered because they have the policy and that's what it's for. So they don't know what to do. So they follow what the insurance company is telling them to do. But the insurance company isn't, like I said before, isn't going to advise insureds about all their rights and all their obligations. This is something that you need to know, or your counsel needs to know, or your broker needs to know. So that was a lead into my reservation of rights quandary. So first of all, before I get into the actual bullet points on the slide, I do want to say that it's really ideal. We're talking about reservations of rights, but in the ideal world, there's no reservation of rights because the carrier has agreed to both defend and indemnify, i.e., cover any judgment amounts that ultimately are determined. So that's the ideal world, assuming it's a situation where you want everything covered and you don't have concerns that the insurance company's interests are different from yours. So I will say that right off the bat. But many situations do require or involve insurance companies issuing reservation of rights. It's very, very common. So here's a quandary, which is sort of an interesting issue, but it does happen. And this is something for you to pay really close attention to. So if an insurance company doesn't issue a reservation of rights, I wouldn't automatically sigh and say, great, this is great. They're going to cover everything. I'm all set. While that is a good thing, you need to carefully evaluate what claims were brought against you and what the end result is going to be potentially. And in doing that, you need to figure out what the interests of you, what your interests are, and whether it's all about money or whether there's some other right or some other equitable or injunctive relief that is being sought by the plaintiff. So, what if an insurance company does not issue a reservation in a case that clearly requires it, where it ultimately is going to be harmful to you, the insured, for it not control the litigation? This also presents a conflict of interest. And I'll give you an example, and I've had this situation arise before. And it's a situation where there's a mix of monetary claims, which would otherwise not require a reservation, and claims for injunctive relief, such as if the plaintiff is seeking something that is not monetary on its face, is seeking the insured to do something or not do something. I've dealt with these claims dealing with like property. If there's an order of conditions or some order on the property that, again, it would impact the insured and their property value and their rights, but it's not necessarily a money claim. It's an injunctive claim. It's asking them not to do something or to do something. So in that case, if an insurance company issues a reservation of rights, that's a case, again, depending on the specific facts, I would consider pushing back because the insurance company is going to have every incentive to settle the monetary aspect of the case. And they don't really understand necessarily the impacts of the injunctive relief that's sought and what kind of damage that could have on you. So, for example, there could be a monetary claim and an injunctive relief claim. And ultimately, they could pay what, the insurance company could agree to pay whatever the monetary amount is. But let's say the injunctive relief would put you out of business if it was issued, or something else really drastic would happen if it was issued. This is problematic, and this is a situation where I would and I have pushed back on a carrier to explain that they really actually do need a reservation of rights here. You need to control the litigation because there's other things at stake aside from monetary damages. And in these cases, sometimes what I would do is I might lay out what those potential damages to you would be, even though they're not monetized, if the injunctive relief was issued. Like, let's say you would worst case, lose your business. It would ruin your whole business. Let's monetize what that would be. It's going to be some substantial number. You really, in these instances, have to communicate, preferably in writing, memorialized, what the issues are and why you think and your counsel thinks there should be, a reservation of rights issued. So this is something I wanted to point out. Don't just say, great, there's no reservation, I'm all set. Review what the plaintiff is asking for, because that'll drive like what your next steps are and whether you're going to agree to give up control of the litigation to the carrier or not, and whether you should give up control or not.
Jill, could I just add, I just, for folks that are attending that are charter schools or other educational entities, I have seen this issue come up as well there. And oftentimes you could have a situation where there's a claim that involves monetary damages and injunctive relief. And that injunctive relief piece might be much more important in some cases to the school, because it may be a situation where it may be a student discipline matter where students expelled and the parent or guardian seeking to have the student return to school, or they're looking for some sort of change to school policy. And so the monetary piece may not be as important, but you're more concerned about injunctive relief that's either going to impact the operation of the school, may intersect with your obligations under the charter school statute or other statutes, or just your ability to control your own policies at school. So this is an issue that I have seen come up for schools, charter schools, and other public schools. So it's just something to keep in mind as well. It does come up in that realm as well.
Thanks, Bettina. That's a great point. Okay, so moving on to reservations of rights and when the insured controls the defense. And we had talked a little bit before about what rights this gives you as the insured and what obligations this confers upon the carrier as the insurer. So, so the two topics that we want to discuss today that we think are really important. So, if a reservation of rights is issued, then under Massachusetts law, the insured has a right to two things, two key points. One, to select independent counsel of their choosing, as opposed to typically carriers will default to their panel lawyers. And two, have the reasonable costs of your lawyers that you've chosen be paid by the carrier. So oftentimes carriers will just say, oh, this is the rate there's a reservation of rights, but this is the rate we're agreeing on. And they're not actually allowed to do that in Massachusetts. Again, other states perhaps, but not in Massachusetts. So with that being said, I'm going to turn it over to Bettina to talk a little bit about the insured's right to select independent counsel when a reservation of rights is issued.
Thanks, Jill. So let's talk first. So the two, as Jill noted, the two rights are the right to select independent counsel and the right to have reasonable costs paid by the insurer. So that sort of first prong or sort of first element of the insured's right to select independent counsel. So first, in Massachusetts, the insured has a right to reject insurer-appointed or controlled defense when there's a reservation of rights that's issued. And this was established in a couple of foundational cases that are listed here, the Three Sons Inc. case and Magoon. And basically, in recognition of, again, going back to this concept of potential conflicts or conflicts of interest, in recognition of the potential conflicts presented where an insurer asserts a reservation of rights, again, the Massachusetts SJC has held that where an insurer offers to defend under a reservation of rights or pursuant to a reservation of rights, the insurer has the right to object to the counsel selected by the insurer. So that would be panel counsel appointed by the insurance company, and insist on having its own counsel control the defense at the insurer's expense. So next slide, please. So then going to the second sort of element of the insured's rights, the obligation to pay reasonable rates or reasonable rates of the insured's independent counsel and reasonable costs. Again, so through its reservation of rights, an insurer's duty to defend is transformed into a duty to reimburse. It's insured for reasonable attorney's fees. And we'll talk about what does that mean? What are reasonable attorney's fees? How do what are we talking in terms of rates in a little bit? But insurers must pay the insured's reasonable attorney's fees when the insured selects independent counsel. So again, the Magoon case talks about this, Moriarty case as well. So now I'm going to hand it back to Jill to talk about some case examples, to talk about what are reasonable rates in the reservation of right intersection.
Thank you, Bettina. So now I'm going to talk a little bit about what rates constitute reasonable rates. So market rates, not panel counsel rates, control. And just to backtrack a little bit, the reason why we're even here is, just to refresh, is because you have the right to control the litigation. So you don't want to go with the insurance company's panel counsel because they're going to be conflicted out. So therefore, you shouldn't be bound by whatever, and you're not bound under Massachusetts law by whatever rates are set by the carrier with their panel counsel. So that's why, just to situate ourselves, that's why we're here. So the law in Massachusetts is very clear, perhaps not the case in other states, that market rates, not panel counsel rates, control. So I've cited a couple cases here, and which are clear in saying that reasonable charges are to be assessed with reference to market rates. An insurer cannot insist on paying only the discounted rate that it has been able to negotiate with their panel lawyers. So the legal standard for determining the reasonableness of the fees is what a reasonable person in the insured's position would pay for an attorney it chooses to retain. So this is critically important. And I will say again, typically, when you're at the stage of the matter where the when you've convinced the carrier that in fact, reservation of rights is in play and you can select your own counsel, often, maybe not always, but almost always, we'll again get a coverage letter that'll say, we've agreed that your counsel can represent you. However, these are the rates. So there's always, even when you get past that first hurdle of like, A, there's a reservation, and B, this is who I want to represent me because there's a conflict, so I can pick my own. I don't have to go with panel counsel. Even then, the rates issue is never resolved until you work through it. And it's really important to work through it at the outset, because otherwise you could waive your rights. So just a few reasons why Massachusetts law has sort of established that panel rates should not control. So what the Northern Security case said, which is a key case from the appeals court on this issue, is that panel rates often reflect what an insurance company was able to bargain for as a large company handling many cases involving many attorneys who want to keep receiving referrals. And second, the justifiable interest of a company such as the insurance company to keep its costs down, especially in routine cases, which may be at odds with an insured's desire to pay more for legal representation in the hope of minimizing legal exposure. And then the second bullet with the Watts Water tax case says that reasonableness is not established by artificially reduced rates negotiated by insurance companies in exchange for a substantial volume of legal work, nor by the carrier's option to select lower price attorneys to achieve a savings in legal costs in cases that it expects such savings will exceed any anticipated increase in damages. So this is really important because again, you're wanting to hire your own counsel because there's a conflict. You can't necessarily compete with panel counsel, their rates, who are getting thousands of cases, sometimes literally, in exchange for representing the carrier. So you just can't compete with that, and that's why, or usually you can't compete with that. So that's why the courts are so firm on this issue and are very pro-insured in this regard. Again, not common or not the case in all states, but is certainly the case in Massachusetts. So now a point of caution, and I sort of made a reference to this a moment ago, but it's really critical for you as the insured to communicate any disagreement you have with the carrier's position at the outset, because if you don't, you're going to have waived your rights. And the same applies with the reservation of rights more broadly. So, if a carrier says we're issuing a reservation of rights, we're going to send this over to our panel counsel, which happens all the time. You need to speak up unless you're okay with the panel counsel. But again, there's a risk because there's going to be a conflict, particularly if there are some claims that are covered and some claims that are not covered. So you need to speak up as soon as possible, because if you don't, there's a very high likelihood you're gonna lose your rights. So in this Northern Security case that I mentioned a moment ago, the appeals court confirmed that an insurer who is defending under a reservation has to reimburse its insured for reasonable attorney's fees based on market rates, not panel rates. So we just talked about that. However, here, the insured didn't push back. And as a result of their failure to push back, they lost their right, and the panel counsel rates ended up governing. So you got to bring these issues up as soon as you see them in order to be able to make the most of your rights under Massachusetts law. So with that being said, I'm going to turn it over to Bettina to just give you some examples of some cases that have been litigated and determinations that have been made by courts as to what constitutes a reasonable rate.
Thanks, Jill. So, the issue of how do you determine what is a reasonable rate, right? So, the case law is clear, reasonable rates, but what does that mean? And, there are not a lot of cases, here's a little sort of high level survey of some cases. Some of these cases are older, you'll see 2003, 2008, but so you have to factor in, inflation and so forth there. But, there is a more recent case down at the bottom, the Alexander v. Department of Corrections case, federal case, district court case that involved an Eighth Amendment and ADA claims, where the court found that $560 to $600 per hour for a partner with 29 years experience, with the assistance of an associate who had 5 years experience at a rate of $345 to $375 was reasonable. So that kind of gives you a sense, for those types of matters, and in this market, what's reasonable. There is also a case, it's not on this list, but I'll just mention it here, a 2018 case from the First Circuit, again, a federal court, where is a case by the name of Gross v. Sun Life Assurance Company of Canada. That was a case, I just mention it because in that case, the First Circuit cited the district court, the lower court, that had noted that Boston has some of the highest legal fee. Boston hourly fees are some of the highest in the country. That was a case where there were a larger case where there were counsel from both Kentucky and Boston. And in that case, so district court said that, First Circuit cited that or quoted that, that Boston hourly fees are some of the highest in the country. And the fee award there that was approved as reasonable was $500 an hour for the Boston attorney and $375 an hour for the Kentucky attorney. So again, just to know, these cases, what's reasonable is generally determined on a case-by-case basis and taking into consideration the type of matter, the scope of the litigation, all of those things. And it's going to be very fact specific. But this gives you a sense of, where the court has come out on different matters over time in both Massachusetts courts and the First Circuit. So next slide, please. So returning to our earlier discussion about conflicts of interest, another area where there may be a conflict between the insurance company and the insured is when an insurance company requires an insured's independent counsel to comply with its own internal billing and operational guidelines. So how this comes up typically is when an insurer either agrees to pay the insured's independent attorney, or you're operating under the insurance exercising its right to retain independent counsel. Oftentimes the insurance company will have a set of guidelines that include billing guidelines and sort of operational guidelines, what they'll pay for, what they won't pay for. It's really important to read those guidelines. They can be, sometimes they're longer, sometimes they're shorter, but really important to read the fine details of those guidelines. So again, insurers frequently require defense counsel even when there's a reservation of rights to sign off on those internal guidelines. What we want you to sort of take away here is just to make sure that you know that prior to agreeing to the guidelines, you want to review those carefully, like I said, to ensure that they don't create a conflict of interest. How might this come up? This could come up in the realm of limitations in those guidelines on what your independent counsel can do as part of its defense of you as the insured. So, for example, one that comes up a lot is oftentimes there are limitations on the use of online legal research such as Westlaw or Lexis. Also limitations on getting transcripts for depositions or, limits like that you want to make sure that you push back on, because, that may impact you want your attorney to push back on, because that could limit their ability to adequately defend you at some point in the future. Even if at the outset you think, oh, this will never go to litigation, won't have to deal with depositions. Well, we can work around Westlaw. It's important to sort of push back on that because you just don't know, what might be needed in the future. So again, defense counsel has an obligation to zealously defend the insured, and to the extent that those guidelines limit the ability for the lawyer to engage in that defense, it creates a conflict of interest. So really important to read them, for your lawyer to read them, and to not just sort of accept them on their face. And again, it's one of those things, if you don't push back in the beginning and you don't document that, you might be waiving your assent to those guidelines. So important to keep in mind. Next slide, please. So again, this issue was considered, this slide just sort of highlights that this issue was considered, acknowledged, and opined upon by the ABA Standing Committee on Ethics and Professional Responsibilities. In these situations, again, just want to keep in mind that the insured's independent counsel will typically be navigating this negotiation with the insurance company. So, but you want to make sure that you understand what the issue is, and making sure that your attorney's sort of taking the steps necessary to push back if needed. The next slide, please.
So one other point I just want to add about the guidelines, and then I'm going to talk about when all else fails. So with respect to the guidelines, I do want to point out that, again, some states have different rules than Massachusetts. Some states have rules that require, or that allow, I should say, that permit defense counsel to follow guidelines, to to follow guidelines, even if there may be some of these issues that Bettina has just raised. So Massachusetts doesn't have anything like that, which is why it's really critical to push back on anything that could be problematic or could impede your ability to defend you. And again, pushing back is actually it's not an insurmountable thing. I think you just need to really, you get the guidelines, you look at them, your lawyer looks at them, they say we can't deal with certain parameters. So you engage in a back and forth with the carrier and say, we'll agree to this, but we can't agree to not use Westlaw, or we can't agree to not have a deposition transcript sent to us. Like there are certain things that are non-starters for us, and you can typically work something out. If you can't work something out and you're going to be bound by them, that's a situation where in the most extreme circumstance, you could have to actually withdraw from the litigation, just like you would if there's any other conflict of interest in litigation. So I think that's just an important point to keep in mind here. So with that being said, let's say all else fails. Let's say you're having a conflict with the carrier and you can't come to terms on the reservation of rights issue, the reasonable rates issue, or other things. So what do you do next? So under Massachusetts law, some of you may be aware there's a consumer protection statute, that's Mass General Laws Chapter 93A, which relates to unfair and deceptive acts and practices. There is also a statute that buttresses that, which is Chapter 176D, which specifically lays out what constitutes, among other things, an unfair settlement claims practice, which includes a whole litany. I think there's a list in the actual statute of like 15 different types of actions that a carrier can take that would constitute an unfair settlement claims practice. So a few that you should be aware of, many of which we probably discussed already today, are if a carrier, for example, refuses to acknowledge and act reasonably promptly upon communications with respect to claims arising under a policy. Another example, which is not on this slide, is where a carrier refuses to pay claims without conducting a reasonable investigation, or if a carrier refuses to affirm or deny coverage of claims within some reasonable period of time. Or the last bullet is a carrier refuses to effectuate prompt, fair, and equitable settlements of claims in situations where liability has become reasonably clear. So, like I said, there's a whole litany of unfair settlement claims practice laid out in the statute, but these are some of the ones that we commonly see as problems. So what do? So again, you're already involved in one lawsuit. You don't want to start another one. You don't want to have to sue your carrier, spend the time and the energy suing them. So oftentimes, again, you first try to do everything you can in your power to try to get a response from the carrier that's acceptable to you and your counsel before you have to litigate. And I sort of use the 176D kind of threat, as it were. I don't take that lightly, and I don't make it frequently, because that's basically when I've reached a point when I can't get any response from the carrier. So first thing I would do, if you're at loggerheads and you can't get a resolution, I always ask to sort of speak to the highest person that I possibly can at the carrier. So if you're talking to an adjuster, ask to speak with their manager, ask to speak with the manager's manager, because the reality is, as we've discussed today, the law in Massachusetts is unique, and many people just don't understand it. It's not that they're trying to be difficult, they just don't understand. And once you're able to get the right person to educate them as to what the law is, you can usually work something out. But you need to be able to, many adjusters are not used to this framework. And so their automatic reaction is, no, we don't know where you're coming from. So take it as far as you can. And if that doesn't work, then first instance, send an email before you get into, filing a lawsuit, saying, lay out the issue. We don't want to, but if we have to, we're going to file a claim under 176D. If that doesn't work, then you can send a demand letter, again, trying to avoid litigating. We're going to be, filing a complaint alleging all these violations of 176D if you don't respond to us. And then if that doesn't work, obviously the last option is to litigate, which can happen particularly if the carrier is just not paying, or the carrier's not, let's say a case should be settled and the carrier's not engaged and not involved. It may happen. It has happened. We've litigated cases like that. But again, that's your last resort, because the last thing you want to do, you're already involved in one litigation. You don't really want to be involved in another, but sometimes it is unfortunately necessary. So this next slide, which I understand has a lot of information on it, but just sort of big picture, the takeaway from this slide is that if you actually do have to bring a claim and litigate, and if you do prevail in that litigation based on an insurer's unfair settlement claims practices, the insurer will have to pay your attorney's fees. So Massachusetts typically has the same rule that most states have, which is that litigants have to pay their own attorney's fees. There are some exceptions to this, like 93A and 176D. But this is a situation where, again, this is where education is really important because the carrier doesn't want to lose in a lawsuit either. So if you can educate as to what Massachusetts law is, as we've sort of laid out today, then hopefully you can avoid having to litigate. But if you do have to litigate, as shown in this Moriarty case, which is a fairly recent case, if you win and you prevail, your attorney's fees are going to be paid. So you've had to spend the time and the effort to like go through the whole litigation, leading a trial. But if you win, they're going to have to pay. So there's definitely a huge downside to them. So education is critically important here. So with that being said, Bettina and I are now going to just run through a few like hypotheticals and scenarios of things that have come up. And Bettina's going to take the first one, but we're just going to go through a couple sort of hypos of situations that arise and sort of talk through how you might want to handle it.
Yeah, so this first one is a situation that comes up. I've seen come up fairly often with some of our school clients when they get, for example, an MCAD matter or other type of litigation where the insurer, so you reach out to the adjuster and ask for a coverage position, and the adjuster reaches back and says, oh, we've assigned it to panel counsel, and there's a reservation of rights. And so oftentimes we'll get the call or the email from the client that says, oh, we're all set. It's already been assigned to panel counsel, and insurance counsel is going to handle it. And then when I probe a little bit and find out that there's a reservation of rights, then we have to have this discussion of all these issues that we've talked about here, which is that they have the right to choose their own counsel. But sometimes, as Jill mentioned earlier, particularly with an MCAD matter where you may have a position statement or response due in a matter coming up quickly, you want to try to address this so you don't have, two attorneys working on a response, but you're also not missing deadlines. And you also are not giving the appearance that you are agreeing that your client is agreeing to use panel counsel. So that's important as well. So, the first thing is obviously you want to speak up right away. Particularly, a lot of times for our school clients, they have the same, there are handful of insurers that are the sort of sending cases to the same firms as panel counsel. So I'll just reach out usually to panel counsel myself and just explain the issue. Oftentimes the panel counsel is also here in Massachusetts and they understand these issues, which makes it a lot easier once you explain to them, because there's a reservation of rights, your client's exercising their right to choose their own attorney. They're fine with that. But again, it's really making sure that you speak up early on, making sure to document all of your communication. You as the insured and your counsel obviously as well, documenting all communication that you've had with the insurance company around all of these issues, reservation of rights, and pushing back on, asserting your right to choose your own counsel. So good documentation is really essential. And then we have, when we have to, really explain these issues to maybe an out-of-state insurer, we have a pretty robust letter that we use that incorporates a lot of this discussion about Massachusetts law and how it is unique and how it controls. But again, though, that's where your attorney can help you, use the most convincing and most powerful language when you do need to push back. So, again, our advice would be speak up early, document all of your communication, and communicate with your own independent counsel if you're getting, pushback from the insurer on those issues. So I'll hand it over to Jill for the next example.
Thanks, Bettina. So the second example is when, and this often happens too, when the insured reports the claim to insurance and doesn't get a response regarding coverage prior to a case deadline. And this often happens we see it a lot in MCAD cases where somebody files a charge and you have, 21 days to respond, and time is ticking and you don't want to lag and not respond, because critically, most importantly, you should make sure you have a defense in the case. Whoever does it, you need a defense. And so the question often arises, like, what do we do? Do we just sit back and wait for the carrier to tell us what the story is, whether there's a reservation, whether there's not a reservation, et cetera, or not? So in this circumstance, I personally if there's a deadline coming up and there's not a determination in short order, I mean, you should give it a little bit of time, but not weeks by any stretch. If there's no determination, I sort of consider that to be an unspoken reservation of rights because there's a delay. The most important thing is that you have an appropriate defense for your case, and you can't just sit around and wait for the carrier because that's not going to be a great justification if you're having to defend to a court, to the MCD, why you didn't respond. Saying, oh, I didn't get a coverage determination isn't going to fly. So you need to defend yourself. And I will say the Moriarty case, which we've talked about a whole bunch today, which is a fairly new case, actually held, and this is very important, that when an insured delays issuing a coverage determination and the insured reasonably retains their own defense, because you obviously want to defend yourself during the gap of time before the coverage determination is issued, the insurer must reimburse the insured for reasonable rates. And this is really important, even if the insurer ultimately accepts the defense without any reservation. So just, and this does come up, just because there's a delay, like let's say they delay a couple weeks or delay a couple months, you hire counsel because you need to defend yourself, and then they say, oh, there's going to be no reservation, we're going to send it to panel counsel. Then in that case, they are obligated to reimburse you for the monies that you spent because they didn't respond in a timely manner. So I think that's a really important thing to keep in mind as well. And with that, I'm going to turn it over to Bettina for the last hypo scenario.
Thanks, Jill. So I know we're almost at time. So the last sort of scenario that comes up, this is also happens fairly regularly in my experience, I think, and Jill's probably as well. At insurance companies, adjusters change roles or leave and, get promoted or go to other companies all the time. So what happens when you've negotiated a rate or your attorneys negotiated a rate with the insurance company, and then a new adjuster comes in and says, either they're, takes a different stance or reverts their position on rates. Again, just, kind of our pitch for keeping good records. You want to just make sure that you have, maintain all the communication. And again, a lot of times all of this communication or much of this communication is by email. So keep all of those records. Again, oftentimes if you're in the middle of a case, insurance companies have billing portals and you'll have a record of having billed at a rate, and you'll probably have an email chain that says that you agreed upon that rate. There'll be a lot of evidence and you'll be able to, as Jill suggested, work it out. But this does come up sometimes, and more of it's not, any sort of like bad faith. It's just, different people coming and going and things get lost in the shuffle. So making sure you keep good records of the rates that you've negotiated or that your counsel's negotiated is really important. So that's just sort of another pitch on the document position. So
one final thing I'll say about that, and then we'll sign off, is that this is also critical and can actually happen if a determination is made at the beginning of the case to issue a reservation of rights, and then a new adjuster comes in and it's for some reason that's maybe they never issued a coverage letter at all. Maybe this was just through email communications with the adjuster, and they come in and say, oh, there's no reservation, or oh, we're not going to pay those rates. In that situation, I have this occur fairly frequently because adjusters, especially for cases that go on for years, do change. I will have an email string from way back when where it was clearly stated in an email that there was a reservation of rights, but the new adjuster might not have access to that because that wasn't saved as part of the claims file. So just important to keep really good records so that if, in the future something changes and somebody's not aware of like what was established at the beginning of a case, that you have that ready and available. So with all of that said, we thank you all so much for being here today. We hope you've learned a lot. We hope this has sort of clarified some of the confusion that typically surrounds reservation of rights. And it was our pleasure to be here today. Thank you very much.
Thanks, everyone.